So I'm Davis Taylor. Some of you may have heard me present at some of these sessions in the past. I'm back. I'm a managing associate director, accountant in the Division of Enforcement and Investigations, and I'm representing that division here. Again, I have to make this little exclamation or disclaimer. The views I express are in my official capacity as a member of the Division of Enforcement and Investigations, but are my own and do not necessarily reflect the views of the board members, or other members of the staff. All right, we should have our first CPE code. I will give you a moment or two to put that in. Okay, so what do? We do a lot, but first of all, I just want to let you know that I have the privilege of really working with our division's highly dedicated, talented accountants, attorneys, and other professionals that serve the board's goal to protect investors. The division is authorized to investigate registered public accounting firms and their associated persons for noncompliance with the Sarbanes-Oxley Act, rules and our rules and those of the Securities and Exchange Commission concerning auditors, along with any other rules and professional standards governing the audits of issuers and broker-dealers. We use our investigative authority to identify serious audit deficiencies and other potential violations of relevant laws and rules that pose significant risk to investors. And when those investigations reveal that conduct has run afoul of professional obligations or have threatened the board's regulatory process, the board, to demonstrate that non-compliant auditors face real consequences, will use its disciplinary authority to impose sanctions and penalties. Our goal at the end of the day is to sanction and deter non-compliant auditors and others similarly situated from violating applicable professional standards, rules, and laws. So today I'd like to talk about a couple things. First of all, our enforcement statistics for 2023 and the first 4 months of 2024. Give you a little idea of the range of sanctions and the effects of suspensions and bars, and some consequences of allowing individuals who have been suspended or barred to associate with firms. Our coordination with both Securities and Exchange Commission and foreign regulators, so we're doing a little bit more of that now. Certain program statistics for 2023 and also 2024 to date. The current outlook and priorities for our enforcement activities. Selected matters involving violations, that we'll talk about a few of those at the end. And then a couple other, well, first of all, focusing on QC violations, which we're focusing on a lot more, as you'll see, and then some other noteworthy settlements. So you can read these yourselves, but you know, we've had some significant increases in the amount of orders that we've issued and the penalties that we've received since the previous periods. Also, about half of our orders now were against firms or individuals outside of the United States. We focus both on domestic and international firms. Also, we've had our first settled orders since we received the historic access to China-based registered firms, which was a very difficult and challenging process that the board has been engaged on for as long as I can remember, and was really ultimately due to the Holding Foreign Companies Accountable Act, which gave us the ability to make determinations under that act as to whether firms were cooperating or not cooperating with us. So again, I think these charts speak for themselves. The last column is only for the first 4 months. So even though it looks like the orders are down in 2024, that's because we only got the first third of the year in there. But even so, our penalties have gone up significantly in 2024 from 2023. Some of that you'll see as a result of one large settlement we did in 2024. But our focus is on some of the things that are in the 2022 to 2026 strategic plan of the board, which is rigorous enforcement of standards rules and laws, and more significant sanctions. And again, you can see that reflected in the monetary penalties here. Here are the range of possible sanctions that we can use. The obvious ones are there, like monetary penalties, suspensions, bars, revocations. But I'd also like to highlight a little bit some of the more forward-looking sanctions that we're using more of these days, such as the appointment of an independent monitor or consultant, or sanctions that relate to, or undertakings that relate to trainings or other changes in policies that are more forward-looking. And you'll see these a lot more frequent in some of our recent orders. All right, now we're gonna have a little polling question here. So what is the largest civil monetary penalty ever imposed on a firm in a PCAOB settled order? Is that 3 million, 9 million, 18 million, or 25 million? What do you guys think? All right. Yeah, 25 million is the right answer. And that is the recent settlement we did with KPMG Accountants NV. This is KPMG Netherlands. Prior to that, the highest penalty was 9 million. It's very important to understand the effect of PCAOB suspensions and bars, even if you, and I know all of you here, never plan to be subject to them personally, because some firms and individuals have been sanctioned for allowing suspended or barred individuals to associate with their firms. So if someone is barred or suspended, they're not allowed to associate with a registered firm. And so you need to make sure you're taking that into consideration. It's also important to note that suspended and barred individuals are also prohibited from taking financial management roles or accountancy roles with issuers, brokers, or dealers, and for entities to allow that to occur. The outlook for enforcement is pretty similar to that over the last several years, but with a continued emphasis on the significant sanctions for conduct. We continue to prioritize investigations that involve significant audit violations that have presented risks to investors, matters that threaten or erode the integrity of the board's regulatory oversight process. These would be things like non-cooperation in inspections or in investigations, and audit matters that relate to significant independence violations, as independence is one of the core concepts of auditing. We're also focusing on matters that relate to deficiencies in firms' quality control policies and procedures, and we'll see later that that's reflected in a number of settlements that we've been getting over the last period. Also, audit matters relating to new and evolving issues such as crypto assets or SPACs, and then expanding the types of cases we pursue, including cases for a single act of negligence where the conduct is very serious, or cases brought under rules that we have previously not charged individuals under. Since at least 2019, enforcement has been specifically focused on matters involving firms' systems of quality control. Firms have responsibilities to ensure compliance with professional standards, and a proper system of quality control should provide firms with the reasonable assurance that they will. During 2023 and the first 4 months of 2024, the board settled approximately 30 matters concerning violations of quality control standards involving both U.S. and international firms. And these settled matters involved all the 5 elements of quality control: independence, integrity, and objectivity, personnel management, acceptance and continuance of clients and engagements, engagement performance, and monitoring. And I will later highlight a few of those settled matters with QC violations. We're next to our next code, everyone. 622. Somebody's writing these down for me. I need to put them in. Okay, everyone got that? Let's talk a little bit about coordination with other regulators. First of all, we coordinate all of our activities with the Securities and Exchange Commission, and we may share information with it also the Department of Justice, and any of the other agencies that are enumerated in the Sarbanes-Oxley Act as amended. Our coordination with the SEC enforcement is standard practice, and that can result in situations where we run parallel investigations, sometimes where the SEC, for example, might be investigating the issuer, and we would be investigating the issuer's auditor. It can result in situations where we may defer our investigation to the SEC of the auditor, or circumstances where the SEC doesn't have a parallel or declines to pursue an investigation against the issuer, but we continue to move on our investigation with the accounting firm. PCAOB has also negotiated cooperation agreements with various audit regulators around the world to facilitate in our collection of evidence, sharing of information, and charging respondents. Some of our foreign investigations have also resulted in parallel investigations with those foreign regulators, where we investigate violations of our rules and standards, and they investigate violations of their rules and standards. A great example of that, and we'll talk a little bit more about that later, is our coordination with the AFM, which is the regulatory agency for auditors in the Netherlands. Okay, we're going to now talk about some recent noteworthy settled matters. So the first one I want to talk about is in the matter of Smythe LLP. And this is mostly a situation of a firm using unregistered auditors. So our rules require that if a firm plays a substantial role in an audit engagement, which is defined in our rules, but basically more than 20% of the audit hours or fees, they're required to be registered with the PCAOB. In this situation, Smythe used work of unregistered firms in a substantial role capacity in several audits. And so as a result, they didn't properly evaluate the professional reputation of the firm. In other words, part of that would be evaluating whether or not, if they're going to play a substantial role, that they are in fact registered with the Securities and Exchange Commission. I'm sorry, with the PCAOB. Also, they failed in most of these audits to determine whether they were in a position to serve as the principal auditor. Part of the requirements under our current using the work of other auditors is, or at least the standards at that time, was that you're required to make a determination as to whether you're doing enough of the audit to serve as a principal auditor. And for example, if you're only auditing, say, 10% of the revenues and the other firm is auditing the other 90%, maybe you're not in a position. You could be. I mean, you have to demonstrate why, but you may not be in the position to serve as the principal auditor in that situation. Also, they were cited for QC policies because their QC policies and procedures concerning the use of other accounting firms either were insufficient in their design or implementation to prevent this from happening in multiple situations with respect to the work of the firm. And as a result, the firm received a $175,000 monetary penalty and certain undertakings regarding system of quality control around the use of the audit work of others. Also to note is this was a Canadian firm, and there were no bars or revocation of the firm's registration. And in some instances, I'm just going to move on, so I want to make sure we're staying on time. The next one I want to talk about is Haney and Company. So there were both firm and individuals were sanctioned in this situation. The individuals were sanctioned for violating PCAOB rules and standards while serving, the engagement partner and the EQR partner on 2 2019 audits. And then in addition, Haney, the firm, violated rules and standards on those audits, as well as PCAOB QC standards for failing to effectively implement policies to provide assurance that that the work done by its staff was meeting professional standards and regulatory requirements, and we'll get into some of the issues with those audits in a bit. And then also to establish policies and procedures to provide reasonable assurance that its policies and procedures were properly designed and that its QC system was effective. So the audit violations were failures to evaluate the fair presentation and respond to fraud risk. A lot of this comes around to something that just seems very basic, but obviously you need to make sure that your quality control policies and procedures address this. But in this audit year, this is the first year of the full implementation of ASC 606, and they did their audit under ASC 605. So they were auditing under the expired standard and not the current standard. In addition, they had received some notification in earlier inspections about some deficiencies in how they were approaching the valuation and disclosure of certain material investments of one of the issuers. And they didn't change their procedures in the audit to respond to those deficiencies and just did the audit the same way they'd done it before. Also, they failed to evaluate the valuation of a significant acquisition because the valuation was based on untested management projections. So they didn't do enough work around looking at the estimates associated with those valuations. And then finally, they failed to obtain sufficient audit evidence for cryptocurrency mining revenue, in part because those procedures were based, again, on superseded GAAP. So in this case, the firm incurred a $400,000 penalty in certain undertakings, mostly around the system of quality control. And then the individuals got a combined penalty of $190,000, bars on the engagement partners, which were 2 years, and practice limitations on the EQR partners, which are 1 year. So this was a relatively serious violation. And now, another CPE code. How exciting. 419, going once, going twice. Sold to the person. All right. The next one I want to talk about is Witham, Smith, and Brown. And this is a situation where we were focused on the firm's rapid growth. In fact, the firm's issuer audit practice increased in 1 year by almost 500%, yet the number of partners it had increased by only 50%. So it's difficult to see how the firm was able to continue to perform all of those audits with the requisite due care that was required under our standards. In this case, it was SPAC clients. They accepted hundreds of audit clients, which put a significant strain on its system of quality control. And as a result, we found that its system failed to provide reasonable assurance that the firm could execute those audits with professional competence, including that it was undertaking only those audits that it was able to do with professional competence, and also to ensure that the partners had sufficient workloads or sufficiently unburdened workloads to discharge their responsibilities with due professional care and competence. In this case, the sanctions were $2 million civil monetary penalty, and then a requirement to engage an independent consultant to review their quality control policies and procedures and make recommendations for improvements of those. So this is the big $25 million penalty case that we settled in April. And this is the 9th cheating case that we've had, exam cheating case that we've had since 2021. And just on a personal note, I find these kinds of cheating to be very concerning, because it just goes to the tone at these firms and sort of the ethical, grounding foundation that these firms have, that these people feel like it's okay, to cheat on these exams that are supposed to be testing their understanding of GAAP and auditing standards and other things. But in this case, the conduct was serious at a lot of different levels. First of all, in this period from 2017 to 2022, hundreds of Netherlands professionals of KPMG, including partners and senior firm leaders, were engaged in answer sharing on tests for the firm's mandatory training courses. And despite being notified of some of this cheating, including the head of the audit practice himself, who was separately sanctioned, Mark Hogaboom, having cheated himself, they never thought to monitor, investigate, or identify any potential unethical conduct. Also, in the course of the investigations, the firm falsely made representations saying that they had no knowledge of answer sharing, even though they knew about it, and in part because certain of these senior executives on the board of the firm were they themselves engaged in this answer sharing. So as a result, we received sanctions from the firm of $25 million in civil monetary penalties. And in this situation, there was a parallel investigation that was being conducted by the AFM. This is the Dutch Authority for Financial Markets, which is the regulatory equivalent of the PCAOB in the Netherlands. And they, the firm also received separate sanctions under Dutch law, which were a lot around undertakings and a higher level of supervision. And then it's not on this slide, but Mr. Hogaboom was permanently barred by the PCAOB. And these violations typically will fall under our QC rules and standards regarding the firm's training program, which is part of personnel management component of internal control, and its overall system of quality control. And one other note, this is the first time we've actually sanctioned an individual in conjunction with these kinds of exam cheating cases. In the past, all of the sanctions have been against the firms. All right, look, I'm only yellow and I'm getting close to the end here, so I'm not gonna make you wait too much for lunch. So just so you know, this is our tips and complaints information. It's available on our website as well. If you go out to our website and just go to enforcement, you'll see a link there. I have to tell you that some of our significant cases do come from tips and other information that's submitted to us through this and other means. So we do take these seriously and we do look at them. And I personally, this is a long time ago, but I was personally involved in a case where a very significant component of that case was a result of a tip. There was other issues at this firm as well, but it was that tip from a former disgruntled employee that opened up a whole other area of investigation for us. So we do look at those. And before we go to lunch, I have one last polling question. So as you all know, and we've talked about several times, the Sarbanes-Oxley Act requires that the funds we collect from these sanctions, monetary sanctions, go into a scholarship fund to fund scholarships for accounting students. And so how many scholarships were awarded in 2023? Is it 96, 396, or 369, sorry, 250 or 402? What do you think? Oh, you get a little diversity of answers from ones here. Well, you already know because it's green, but the correct answer is 369. You know, we're and hopefully with this $25 million, we're going to be able to expand our scholarship program even further. You know, maybe we can make a small dent in the pipeline problem by providing additional scholarships for needy and worthy students. So I know we're on the way to lunch, but do we have any questions? I don't know if anyone's been following questions. I'm certainly going to be around at the break and afterwards if anyone wants to ask me a question. Now, I have to warn you, if it's very facts and circumstances specific, I probably can't answer, but more generally, I can certainly talk about our activities. Thank you again for your time and enjoy your lunch.